Everyone. Okay, so I'll get straight on. So today we're looking at a comparison between NEC and JCT. So we're going to be focusing on NEC and what we've learnt so far in the last couple of webinars, building on that and comparing it to JCT. Pretty high level, not on a clause by clause basis. So if we can move on, Jen, probably a couple of slides to the intro. Yeah, lovely. So what we're going to be looking at is a history and sort of the ethos of both of the contracts. And then we'll move on to how they are formatted. So what the indexes look like, what the clauses look like, etc. And some of the risks in each and the differences between them. We'll pretty much cover those issues all together. As we proceed with the slides. So if we can move on to the next slide, please, Jan. Okay, so and some of these, as I say, building on slides you will have seen probably in the first webinar that we did in September, and also to an extent in the options C and D webinar that we did last month. So you will have seen this slide up to the final, but excluding the final point. So fundamentally, it looks at the background to NEC. So it was introduced in 1993. You can see that, you know, why we say it's a new contract, because the final bullet point refers to JCT, which was introduced in 1931. So actually not long till it has its 100th birthday. So you can see why, you know, NEC is considered new. You can also see there the sort of iterations that we have of NEC. Obviously, we have similar with JCT. I haven't listed them because in almost 100 years there will be a lot. But just for your information, the most recent is JCT 2024, which unsurprisingly was introduced last year in 2024. So that's what we're going to be looking at today in terms of the comparison. Next slide, please, Jen. Okay, so again, this slide should be familiar because we had it back in September. It's a pretty dense slide, but if you divide it into sections of 4 bullet points, it becomes much more manageable, and it just sets out all the different contracts in the NEC suite. So first of all, the first chunk of 4 is the engineering and construction contract. That is probably the one you will be using as a contractor. And then the third bullet point, the subcontract, if you're a subcontractor. And bullets 2 and 4 are just the short forms, which I wouldn't imagine that you are using hugely. The next 4 bullet points, term service contract and short form. So that's basically, rather than doing a project, a specific build, as the first 4 contracts are designed for, this is for something like maybe a maintenance over a specific duration. So I don't know, maintaining roads for a 5-year duration, something like that. And then the next 2 are the professional services contract and short form. And interestingly, what we will see with JCT is that they don't have a blanket professional services contract. So arguably this is one advantage that NEC has. And of course, as we saw in the first seminar, if you pick up particularly bullet 1, the ECC, the contract, and compare it to bullet 3, the EC subcontract, the clauses will be pretty much the same, save that the terminology is different. So, for example, you're not talking about client and contractor, you're talking about contractor and subcontractor. So obvious things like that have changed. But other than that, the clauses pretty much mirror each other, which makes it easy. And it's a similar point for bullets, or are they 7 and 8, the professional services contracts in the short form. It's not as identical, if that makes sense, as the contract and subcontract, but the clauses that you will be reading will be replicated from your ECC and your ECS. Next for, we have the supply contract and short form. So that's just supplying materials where no installation is required from the contractor or subcontractor. Then we have a framework contract. We'll see there is one for JCT and dispute resolution provisions, again, similar for JCT. And then the two new contracts that were issued with NEC 4 are the design, build and operate, which is what it says it is. It's a design and build contract with the add-on of the operational provisions after completion, presumably for a number of years. And then finally, the slightly out of the box contract, the alliance contract, which is the single contract for all the major parties, single project insurance. It's basically a super collaboration contract, little opportunity for claims. Definitely wouldn't be kind of rushing off to adjudicate on that form of contract because it is this super collaboration. So they are the NEC contracts. And what you need to bear in mind is that whilst that's a really big slide, it is one slide that sets out the contract. So if we can move on to the next slide, please, Jen. So this is the first of 3 slides setting out the JCT contract. So immediately there are far more in this suite. That's partly because a lot of these are, so they are a mixture of the contract, the subcontract, and, oh no, there's no short forms here. So they're a mixture of contracts and subcontracts, but these are all different pricing options. So whereas we basically just had 2 contracts, so it was bullets 1 and 3 on the previous slide, the ECC and the engineering and construction subcontract. For JCT, we've got all of these contracts. So, of course, if you're familiar with JCT, the first one, the design and build, is the most commonly used, and then the design and build subcontract underneath it. But other various pricing options, so with and without quantities, approximate quantities. And interestingly, we've got a named subcontractor agreement right at the end. Now, we don't have that in NEC, so that's sort of altering liabilities for subcontractors, you know, as between the developing party, the paying party, the contractor and the subcontractor. But historically, that is something that was done to an extent, but I mean, certainly in the 25 years-ish that I've been doing construction work, it's not been a common theme at all. In fact, I've come across it once in that time. So if we can have the next slide, please, Jen. So we've got the minor works contracts, so that's the equivalent to the short form contracts that we have with NEC. So both the contract, the subcontract. We also have, so sort of about 2/3 of the way down, you'll see the pre-construction services agreement. That's one that is used fairly commonly, so it is what it sounds like. You enter into that prior to entering into, for example, your design and build. And the idea is that you do pre-construction services. So you might be doing some design, you might be finalising your price, you might be doing some ground investigations. But this contract allows that work to be carried out, allows the contractor to be paid for it. But obviously, if it's paid for and then the design and build or whatever follow-on contract isn't entered into, then that's at the option of both parties. And then we have At the bottom, the works, the management works contract, and also the management building contracts. They're just two slightly different versions of management contracts where a contract goes in and manages the trades, the subcontractors, and the liability of the contractor for those subcontractors is limited depending on which one of those contracts you use. So my experience of those two contracts, both of them, the management one, the management building and the management works, sorry, the trade contract and the management contract is where, for example, main contractors partway through a build become insolvent, and a new contractor has to be brought onto site to finish the works. Quite often, new contractor won't want to take the works on as a design and build, so they come in as on a management basis, and quite often the existing subcontractors are novated across, either to the paying party or to the contractor. So if we can move on to the next slide, please, Jen. So this is the final slide in the suite of JCT. Just a couple to pick out. We've got a framework agreement there in the second bullet point, in the same way as we have for NEC. We've got a prime cost building contract where work is done at cost by a contractor, and then a form of fee percentage is added to cover overhead, profit, etc. Couple of adjudication agreements, which we don't need to consider too much. And then we have the consultants agreement for the public sector, and we have a repair and maintenance contract. So far more contracts, as you can see, and you know, in some ways that's why I quite like NEC, because it's just a bit more self-contained. That engineering and construction contract works and can be adapted to a variety of cost mechanisms, which we'll come to in a minute or so. So can we have the next slide, Jen, please? So other documents in NEC, again, we have seen this before in September. So we have the guidance notes, which are very useful. There is a sort of JCT equivalent, but probably really, I find that it just sort of explains the clauses, just sort of paraphrases what the clauses say. So possibly helpful, but I don't tend to refer to it. Flowcharts for NEC 3, not for NEC 4. And of course, we have the NEC Q&A that we've discussed. So if we can move to the next slide, please. Okay, so sort of drilling down a bit more, we're going to look at the indexes for each of the contracts. And again, I think we've seen this slide for the engineering and construction contracts, so for NEC. And, you know, this is high level. It contains the core clauses, and we're going to look at the index for the core clauses shortly. The dispute resolution is separate, and that's because it's an international contract. W1 is for the international element, and for elements where Housing Grants Act doesn't apply in this country. And W2 is for this country where the Housing Grants Act applies. So the key thing there is that it includes the right to adjudicate at any time, whereas W1 is so that's a statutory requirement under the Housing Grants Act, whereas W1 contains a contractual right to adjudicate, but it's not at any time. In fact, it's very time limited. So if you are ever under a W1 contract, you need to be aware of that. If any dispute arises, you need to be pursuing it from day one. And in fact, you have about 2 to 4 weeks to refer it to adjudication from a dispute arising. If you fail to do that, then you're time barred. So you cannot pursue through adjudication. And because you have to adjudicate under NEC, both W1 and 2, because you've got to adjudicate before you can proceed to court, it means that you have no remedy. So just be really careful about that if you are ever on a W1 clause. And in fact, before you sign up to it, my advice would be get those clauses amended, and get the time limits removed so there's no time barring. Because particularly as contractors and subcontractors, you are likely to be the party making the claim. Then we have our secondary option X and Y clauses. We looked at those, and if you remember, they tend to be not exclusively, but they tend to be commercial clauses. So what are the delay damages going to be? When do they click in? What is the retention? When's it paid? When is it released? Things, other securities for the paying party, performance bond, parent company guarantee, and then a few other issues that we'll come to later. And they're all option clauses. So if you don't opt into them, if they're if they're not included expressly in the contract, then they don't apply. And where do you include them? Well, the contract data part 1 and part 2 at the bottom, that's where you've got to expressly say they apply, they're included in this contract. Contract data part 1 and part 2, whilst we're here, is the bit of the standard form contract that the parties complete. So it's typically, again, commercial points. So the equivalent for JCT is the contract particulars. So, and any standard form, whether it's the ones we're talking about, FIDIC, ICHEME, they all have a section to be completed, not least for things like, well, what's the contract price? What's the completion date? How long are the works going to take? And that's just for starters. So just going back to the Z clauses, they're the amendments. So the equivalent under JCT, you would typically be called, they are just amendments, but typically it's called a schedule of amendments. And interestingly, part of what we're going to look at today is how the contract started, and there were completely different contracts, poles apart, and gradually in small ways they have adopted parts of the other contract, and sort of gradually conceptually they have got closer and closer together. And what we see, so ever since I can remember, you would expect to get, I don't know, between 20 and 50 pages of amendments in a JCT schedule of amendments. Up until about, 8-10 years ago, you would expect to get very few Z clauses in NEC, limited to things like legislation that the parties were to comply with. So, obvious legislation like the anti-bribery and corruption legislation, anti-slavery legislation. But more recently, that's turned completely, and it's now very similar to JCT. You're looking at 20 to 50 pages of Z clauses, and in fact one that I looked at recently did have 50 pages of Z clauses. And then finally, for the ECC, right at the back of the contract, we have the schedule of cost components, which sets out what costs are payable. So it's sort of a list of rules as to what the contractor is entitled to claim in certain circumstances. So those circumstances being for compensation events, and also where you're on an option E contract, so cost reimbursable, and also when you are an option C and D for the cost of the work as you progress, it's what you can claim for that work as you go along. So that's, and how that is set out is the order in which it appears. So note that the contract data part 1 and part 2, the part that's filled in, is right at the back of the contract form, and that contrasts with JCT, where it's pretty much, it's about the second document within. Well, actually, it's right at the top after the index, I think, so very early on in the contract. So if we can move to the next slide, please, Jen. Thanks. So the JCT, so this is the design and build 2024. So it includes a form of agreement to be signed. It includes recitals, and you might think, well, what's that? And it sort of shows that, you know, this is an old style contract, because the recitals just set out the factual scenario. So they recite what the sort of high level issues are between the parties. So it's the bit that says, you know, whereas, you know, the employer, you know, wishes to have various works done, namely, you know, construction of a block of flats, you know, in a specific location, etc., and you know, the contractor, you know, has agreed to carry out the works and, you know, design the works, you know, and the parties have agreed that the price to be paid will be X. So that's the sort of what you include in the recitals. Then we have the contract particulars. That's the bit that gets filled in between the parties, so the commercial issues. And then we have the conditions of contract, so the clauses 1 to 9, and then we have the schedules 1 to 7. If I was to guess, I don't know the background to the schedules. They seem to have been sort of added over, you know, the course of the development of the contract. And what we will see is that in some cases they are options given to sort of change the way in which the contract works, and sometimes changing it so it's more like NEC. So we'll come to that in a minute. So if we can move to the next slide, please, Jen. Okay, so the contract document. So we've looked at the contract form itself, but it would be a really rare contract in construction where you have a contract that you sign and there are no documents appended to it. Not least because we've got the first bullet point for these two. In the NEC, we have a scope of works or works information, super critical document. And in the JCT design and build, we have the employer's requirements and the contractor's proposals. Probably the most important document within the contract, because they are what sets out what the works involve and therefore what has been priced. We also have, for JCT, we have the contract particulars. NEC, we have the contract data. That says part 2 because that's the part that the contractor completes. Part 1 is the part that the paying party, so the client, completes. Yeah, so we just skip that next bullet point. We also will have some Z clauses, whether they're heavily amended or not, ditto for JCT. And just going back to that earlier point, which is about how the works are priced. So we're going to deal with that later on in a little bit more detail. So the next slide, please. Yeah, so for just continuing the theme of the additional documents to be incorporated into the contract. Obviously, we've got the works information, or as it's referred to in NEC, for the scope. and the JCT equivalent. In NEC, we would have site information, which gives the opportunity of a compensation event, so more time and money for a contractor if it experiences site conditions that don't marry up with the site information. Fairly limited, and what we tend to see is in the Z clauses that's excluded. So the risk is moved for all site information, all ground conditions to the contractor. In JCT, there is no site information and very little, if any, reference to site conditions, ground conditions. And that's just because fundamentally, under JCT, the contractor has to build what it has promised to build. So if that means, building it on top of difficult ground conditions, it's just got to deal with that. If the ground conditions are nice and easy, then that's good news for the contractor. So basically, under JCT, the ground conditions are the contractor's risk. So the next item, we will generally have other documents. So we're talking about collateral warranties, performance bond, possibly parent company guarantee, those other securities for the paying party. And it's exactly the same for JCT. For NEC, we might have or almost inevitably, we will have an activity schedule or a bill of quantities in one form or another. And for the JCT design and build, we have a contract sum analysis. Just be careful though, because the activity schedule bill of quantities is all about getting paid for that work. It's not to be used, of course, for pricing any compensation events, because as we've seen under NEC, compensation events are priced using that schedule of cost components at the end of the contract in conjunction with the figures and percentages in the contract data, and it's predominantly in the contract data part 2. Whereas the contract sum analysis in JCT, it is used for payment, but the way that variations and other costs are quantified in JCT is by reference to analogous costs and rates in the contract. So if your contract sum analysis has rates for, I don't know, some bricks, and there's a change to the works that requires further bricks, typically you're required to use that pricing for the change pricing mechanism as well. So completely different way of pricing extras and extra time. And if there isn't, in this example, if the contract sum analysis doesn't contain any reference to bricks because they're not needed, it's only needed for the changed work, then you refer to what's generally a reasonable rate. So it kind of means that there's more flexibility with JCT, but also there's then more scope for disagreement, because obviously what's reasonable to me, it might not be reasonable to you because we're coming at it from different perspectives possibly. And even when you're looking at rates in the contract sum analysis, there's always reasons why one party might not be happy with them. And then finally, in NEC, you might have an accepted programme sewn in or included in the contract if that is what is agreed. If it isn't, then the party carrying out the work, contractor or subcontractor, must provide a programme, usually within about 4 weeks of starting on site, for the acceptance of the project manager. My preference is to get it included in the contract, because first of all, we will see that there is a cost penalty if you don't submit your programme within the timescales after starting on site. But for me, more importantly, if you submit your programme for acceptance to the PM and the PM rejects it. You know, I've seen projects where the first programme is never accepted. So it just means you never have that critical base programme from which you can at least attempt to assess any delay claims as you go through the project. So that's my preference. JCT is pretty silent on programmes. Typically, the first programme might be sewn into the contract, but quite often it might be quite a rough and ready programme, so not really adequate for assessing delay. And usually there will be no further programmes submitted until you get to completion. Now, it's a value judgment because, of course, the quid pro quo to that is that for NEC, you will inevitably have to have some kind of programming resource available through the project to produce the updated programmes. So you're going to spend through the project on a programmer that you wouldn't do with JCT, but when you get to the end of the project or when you're submitting your compensation events, you are able at any point to say, this compensation event is causing this critical delay and I can prove it because I've got all of these programmes to show it. Whereas, of course, you can't do that with JCT. So from that perspective, I always think you spend a little bit, hopefully, on a programmer on NEC, but it stands you in good stead for negotiating your compensation event claims. And of course, if you look at it from the paying party's perspective, they know that all those programs exist. So if you can't resolve the quantification of the time and the money for a compensation event, it's easy for contractor or subcontractor, or should be easy, to adjudicate and get a determination. Whereas, of course, with JCT, you've got no programme or often, quite a sparse programme. So the first thing you need to do in order to prove a delay claim is get some kind of delay analysis prepared retrospectively, which is always really expensive. And of course, now that contract administrators know the difference between NEC and JCT, they are going to challenge any JCT claim for extension of time and say, well, where is the programme? We can't give an extension of time without a programme. So the party claiming, contractor or subcontractor, is immediately on the back foot. Okay, so if we can move to the next slide, please, Jan. Okay, so these are the NEC core clauses. We've looked at these before, and apologies, please don't all start shouting. We've missed out number 9 at the end, termination. Apologies for that. Any construction contract will typically have a termination clause as a core, as in a key or an important clause. Now, what we see here, the numbering is slightly different, but this pretty much follows the JCT contract, as in the headings for the clauses. So we've got our general clause, definitions and sort of miscellaneous provisions. Next one is, what does the contractor have to do? That would be helpful in a construction contract. Next one is time and programming. We've seen how important programming is. Then 4 is quality management, which also deals with defects. 5, payment, fairly important. 6, compensation events, so that's changed work. What's the word? The paying party inconveniencing or preventing the contractor from proceeding, causing delay and losses, etc., and also the cost of any delay. So it's that trio that we see that appears separately in JCT. Title is around which, when do the goods pass from one party to the next? And then we've got an insurance provision at 8, and then, of course, 9, termination. So if we can move on to the next slide, and can we move on a slide, please, Jen? We'll come back to that. So these are the JCT conditions, and you'll see one mirrors NEC. It's, you know, definitions and sort of miscellaneous. Two, carrying out the works. Of course, two with NEC was contractors' obligations, so pretty much the same. Three, control of the work. So that is about the contract administrator and, you know, what their role is. Now, the project manager in NEC, their role is in part in section clause 1 and then part just generally through the contract. Section 4 is payment. We saw that in NEC. Section 5 is changes, so that's basically variations. Extensions of time are in section 2, right at the end, and the money relating to extensions of time, so the loss and expense, is at the end of section 4 because it's about payment. So there is a logic there. Section 6, insurance, we saw that with NEC. 7 is an extra, so that's about performance bonds, guarantees, third-party rights, collateral warranties, etc. They are all in our optional X clauses in NEC. We've got our termination clause, and then finally we've got settlement of disputes. And obviously with NEC, we know that for disputes, we've got our W1 and W2. So if we can just go back to that previous slide, Jen, please. So these are the articles of the contract. So it's just setting out the key requirements. So, you know, for example, you know, Article 2 is the contract sum, fairly important. And 8 to 10 dispute resolution provisions that go hand in hand with the dispute resolution clauses that we've just looked at. So if we can move on 2 slides, please, Jen. Lovely. And these are those schedules that I referred to previously. And you can see that they're probably, you know, they've been added as the contract has evolved over the years. So the design submission procedure, because the traditional, well, I don't know whether you can call it traditional now, but traditionally, construction wasn't done on a design and build basis. It was done on the basis that the paying party would engage the consultants to carry out the design and then separately engage the contractor to carry out the work. So the paying party didn't have that sort of one-stop shop in terms of, you know, I pay the contractor and the contractor pays all the other parties. If I have a dispute or a defect, I pursue the contractor and the contractor has to claw back monies from any of the other parties, consultants or subcontractors, who the contractor thinks will be liable for those issues. And then Schedule 2 supplemental provisions, not particularly descriptive, but a big chunk of that is very similar to NEC. So it's about where you have extra money because of variations or changes, or extra money or time because of an extension of time or the loss and expense. You can use this mechanism to provide a quote up front, so before the work is done, certainly before the, you know, completion is achieved, and the contract administrator can accept that quote. And once it's accepted, it's binding on both parties, which means that neither party can then, you know, come back later on and say, oh, well, actually, I want to pay less, or, you know, I want to recover more, which is sort of along the lines of what we have with NEC, where the project manager and contractor can agree a quote, and that is set in stone between them. It's not set in stone as between the paying party and the contractor. So the paying party can still revert to adjudication at some point to get a final determination on it. And then Schedule 3, insurance options. Excuse me. And then Schedule 5 is third-party rights. So that's a substitute for collateral warranties under the Third-Party Rights Act, just to avoid it. Pretty much gives similar rights and obligations as collateral warranties, but without having the hassle of collateral warranties. And then finally, the form of bonds, performance, advance, etc. So if we can move on to the next slide, please, Jan. Thanks. So again, this should be familiar from September and actually from last month. So these are the pricing options in NEC. The important thing to remember, of course, is that these are all available in that engineering and construction contract that we have. You know, they are options, so you pick whichever option you want to apply. So if we can move on to the next slide, thanks. So these are the JCT pricing mechanisms. So we've separated them roughly into lump sum, remeasurement and prime cost. Excuse me. And you can see that there are a number of contracts for each. And the other thing is that, you know, where we have a flow through of clauses between our engineering and construction contract and subcontract, and as we've seen to an extent, the professional services contract, there is a flow through on all of the JCT, but it's not as clear a flow through. So, I mean, you know, certainly, you know, if I'm looking at a contract or a subcontract on NEC, you know, I know them so well. I don't really need to sort of check the changes between them because there are very few differences between them. Whereas, you know, I absolutely would need to review whichever contract was applicable to check which clauses applied and which ones didn't relative to the design and build. So maybe not quite as efficient in that regard. So next slide, please. Okay, so looking at compensation events, which is what we have for NEC, and changes for JCT. So when I'm talking about changes, that's sort of loose. We've got changes at clause, I think it was clause 4, wasn't it, in JCT. But of course, we also have extensions of time in clause 2 and loss and expense in 4. Sorry, changes were in clause 5. So I'm bundling them all together because that is what compensation events cover. So for NEC, if you're providing a quote for a compensation event, you must remember to include all 3, because what you don't want to do is miss a couple of elements and then find that the project manager accepts the quote and you then it's been implemented. So you can see on the left-hand side the NEC process fairly roughly, but we sort of touched on this again back in September. But and what we need to be aware of is the fact that this process comes again with penalties if the contractor or subcontractor doesn't comply, and that's because, you know, of this ethos in NEC that it's about no surprises. So, you know, all of this is designed to ensure that the paying party knows what is going on as and when the project is being progressed, because historically we had an issue with JCT where typically, you know, you might end up with a situation where the works were completed paying party pays the lump sum or pays for the works. Contractor leaves site, submits its final account, and suddenly the price has gone up by 50%. Total shock to the paying party, and didn't really help the construction industry in terms of reputation. So part of the ethos of NEC was to avoid that. So of course they had to put in penalties, they had to put in checks and balances to make sure there were no surprises for the paying party, and also penalties to incentivize the contractor or subcontractor to comply. So we have early warning notices and penalties for not complying. We also have a requirement to notify a compensation event within 7 or 8 weeks, depending on whether you're on a contract or a subcontract, and a penalty if you fail to do that. The penalty being pretty nasty in that you won't be entitled to any payment at all or any extension of time. And of course, if you're not entitled to an extension of time, you may also end up having to pay delay damages as well. You know, they are the two, the early warning notice requirement and also that provision are the two sort of penalties on the contractor or subcontractor and a subcontractor in subcontract to ensure that they comply with these timescales. There's also a requirement to submit quotes, and that's a prospective quote. So you're quoting today on site for work or extra work or interrupted work via a compensation event that you are going to be doing in, say, the next few weeks. It's not a case that you've completed the work, you've left site and you are now providing quotes. Under the contract, that is too late. And in contrast, JCT sort of has timescales for notifying these claims, but it's a bit softer. So they actually say that notices have got to be issued forthwith on discovery of a change, an extension of time, a loss and expense item. But in reality, the case law, which is predominantly the case of Walter, Lilly and Mackey, is a little bit more generous to contractors and subcontractors, and sort of says that providing the contract administrator was aware of the issues at the time, then the contractor won't be penalised for not issuing a formal notice. So if you can show that in an email the contract administrator was told about it, or that the contract administrator was telling the contractor, or there's an item raised in a minute of meeting, as long as there's some evidence, then the notification requirements aren't rigidly required. However, having said that, it's good practice to issue them. They are required under the contract. So if we can move on to the next slide, please. Yeah, I think that's just repetition, so apologies for that. And the next slide. Yeah, so in terms of claims, yeah, we've pretty much covered that, so we can move to the next slide. This is where we discover that I've talked too much in the first half and covered everything. So yeah, I think we've pretty much covered the point about programming under NEC as compared to the lack of programming requirements in JCT. The first bullet point under NEC is the point that if you're late in submitting your first programme, 25% can be deducted from your account until you have submitted it. That's quite a big chunk. So, that is the incentive to provide the programme. Of course, if it's already sewn into the contract and agreed between the parties, that stands as the first programme, so that covers it. So next slide, please, Jen. Yeah, just some of our optional X clauses. So we've looked at these and they sort of fall into a couple of categories. So the first is some clauses to protect the contractor. So these two, X15 and X18, are two such clauses. Also X's 1 and 2, which are compensation events for inflation and for changes to the law respectively. There's then a group of X clauses which are additional securities to the paying party. So the third bullet point is one such example. Parent company guarantee, also performance bond, retention is dealt with as an X clause, etc. And in terms of the JCT, so the X15 reasonable skill and care, that is included in JCT as a standard where there is a design liability, which is where it's required. The limitation of liability in JCT generally is not as extensive as the limitation of liability at X18. X18 limits liability in several respects. So it deals with consequential loss. It covers an entire cap on claims. It limits time in some cases, whereas JCT, particularly the design and build, focuses on consequential losses only. So it's not as good for a contractor or subcontractor. And as for, the securities, parent company guarantees, bonds, retentions, liquidated damages, etc., they're all included in the JC, in the main form of JCT. So next slide, please. Payment, not much to say on payment, and that is because the Housing Grants Act, which is an act of Parliament that mandates to a great extent how payment is dealt with in construction contracts. So when I say mandates, you can't contract out of it. So, that applies to both contracts. So barring, extending dates for payment or, reducing dates for payment, there's little leeway there. The one thing to note is that the NEC has no mechanism for provisional sums, whereas the JCT does. So you just need to be careful with NEC, because if you do want provisional sums, they can be incorporated through the Z clauses, but you just need to ensure that they're properly incorporated so that, when the provisional sum will be payable is clear, how much will be payable is clear in those Z clauses. So if we can have the next slide, please. Ground conditions again. I think we've pretty much covered that. It's a possible CE on NEC if the ground conditions are different to those in the site information, providing the Z clauses haven't pushed that risk over to the contractor, which is fairly common, and that's why I've said it's often amended. And under JCT, sadly for contractors and subcontractors in the room, it's your risk, unless again there's a specific provision to risk and move it in back to the paying party. So the next slide, please. Okay, so the final account and the finality of it. So up until NEC 4, there was no final account in NEC, which seemed a bit strange at first, but it just sort of worked in that the contractor can continue submitting applications for payment until the end of the defects period. And then if the final application for payment, if what is claimed isn't paid, then and can't be negotiated to the satisfaction of both parties, then inevitably the contractor decides whether they just leave it and walk away or do they pursue it to adjudication. So it all worked quite nicely. In the meantime, we have always had in JCT some form of final account mechanism. So similar to what I described with NEC, it usually starts the mechanism at the end of the remedial period for the defects. But in the different contracts, there's typically a slightly different process. And JCT has always had a provision that says that ultimately one party or the other is entitled to submit a final account or final statement. Terminology changes slightly, and that if the other party doesn't challenge that final account or final statement or whatever the terminology is within a certain period of time by starting typically an adjudication, that party is deemed to have accepted it. Now, in my experience up until now, parties haven't really enforce those provisions between themselves. And I suspect that's because possibly weren't aware that they were in the contract. I suspect parties will now be aware because with NEC4 and an example of it kind of getting closer to JCT, they introduced a requirement for a final account to be provided. And there is also a similar, it's not the same mechanism, but a similar mechanism whereby effectively if one party will be entitled to submit the final assessment in this instance or final account, and if the other party doesn't object and either refer the matter to senior representatives or adjudication, they're deemed to have agreed it. So these are dangerous provisions. I'm not keen on them because in my experience, you argue them, when you think that your client's on the right side of the provisions, and the adjudicators don't like to find that it's final and binding because it feels quite dramatic and quite drastic for the losing party, particularly, for example, if you're the paying party saying to an adjudicator, I submitted the final account or the final assessment, the contractor didn't respond within I think it's 4 weeks that they had to respond, so therefore they're deemed to have agreed it. In circumstances where the contractor has consistently applied in the interim payment applications for sums that haven't been certified, because everybody then knows that in reality there is a dispute and they've just missed the deadline. But anyway, that's where we are at the moment, and as I say, an example of contracts moving closer together. So the next slide, please. Okay, so I'm just going to very quickly go through these. Our mutual trust and cooperation in NEC, which has always been there from the outset, has now been introduced into JCT 2024, as you can see there. So before that, we didn't have it in JCT. We do have it now. So if we can move on to the next slide, there's just a couple of points I want to make. So NEC4 again introduced back in 2017 some collaborative measures around if the contractor can find a way to reduce the cost of something, then there's a mechanism for the parties to share that cost saving. And again, JCT 2024, clause 2.1.5 in that second bullet point has introduced a sort of similar provision. So if we can move to the next slide, Jen. So that's just about NEC, so we'll skip over that because we have actually looked at that slide previously. And I think the final bit is the dispute resolution process. So I've already mentioned that under NEC, you've got to adjudicate before you can go to court. NEC 4 introduced a new mechanism which goes before adjudication, and that's a senior reps or representatives process. And it is basically both parties put in submissions. The senior representatives, who would usually be director level from each organisation, meet to try to reach a resolution. If you can't reach a resolution, you're free then to go off to adjudication. You don't have to use that mechanism. You can ignore it and go straight to adjudication. But, you know, I think in a lot of disputes, it would be quite a good thing to do. And JCT 2024 has introduced a very similar mechanism, not as structured, but it requires the nominees, representatives to get together to try and resolve things. So if we can move to the next slide, which I think, and then the next one, which I think is the last one. Yep. So in summary, NEC is more prescriptive. It's a more process-driven contract, and particularly as regards payment for extras. There's a little bit more wriggle room with JCT than there is with NEC, albeit that our schedule of cost components should cover what we need. As we've seen, they are sort of getting more and more similar as they go along, but still, please remember when you're operating NEC, it is about, you know, operating and fulfilling the contract requirements and contract obligations now, you know, submitting your paperwork now, not leaving it all till completion, because you will come unstuck with those provisions that kind of result in you not being entitled to any payment. JCT more flexible, but even so with JCT, you know, we should be submitting notices when, you know, it becomes apparent that we have extra work to do, or we've suffered some delay, and or, you know, we're going to be claiming loss and expense. It's a good discipline to get into, and also once you've identified it, it means that you know, you are aware of it, and you can ensure that sort of timesheets have completed properly, so that you can ensure that you can claim the full amount that you're entitled to, rather than losing out because timesheets, documents, you know, aren't in proper order necessary to prove how much time and cost issues resulted in. So that's everything for today. Thank you. Apologies, I've gone over a little bit. Happy to answer any questions, but please do feel free to leave if you've got to get off for the meetings.